Now, you may have seen that Mr. Dyson, as in the vacuum cleaner guy, not the Dyson Sphere cosmology guy, has thrown the towel in his defamation claim against Channel 4 News. So what's all that about? And it also gives me an opportunity just to chat about defamation generally, but to explain what his case was, because there's some quite interesting features in it. Channel 4 did, just let this nice chap come back with his diving gear, because I'm at a lovely place called Crantock today to try and get some nice views, although the sun's just gone in, typical. I've got my sun hat on. But yeah, Channel 4 did an investigation, because all these vacuum cleaners, they're made in a factory in Malaysia. And it turned out the staff were treated, well, less than in accordance with sort of union rules. I mean, they were literally sort of like physically beating them. And Channel 4 did an investigation into this and they reported on it. And Dyson, they came back, the company, and said, well, look, you know, we engaged somebody when this was brought to our attention. We engaged a company to go in and find out what was going on and investigate. And imagine our surprise when everything you said turned out to be true. But rather than sort of address the problem, they just stopped using that factory. And Channel 4 said, well, that's fine. Let's see what this report says. And their argument was, well, you know, we're saying this had been brought to your attention and there is evidence to show that it was. But 3 people brought the claim, Mr. Dyson himself personally and 2 Dyson companies. Because what they said was, well, all you've actually done is say Dyson. You haven't identified who you're talking about. And we have, you know, 2 companies, one of which took care of the manufacturing side of it. The other thing was just the distribution. And also Mr. Dyson himself said, well, you're effectively saying this is all down to me. Oh, sorry, let some more people pass. Hello. Trying to fall into all the bracken again. No worries. So there's a preliminary hearing actually where Channel 4, you know, with defamation you always have these preliminary hearings. So before a Channel 4 put a defence in, they said, well, hang on, we've not even said anything bad about Mr. Dyson personally. And the judge said, yeah. So he struck out the claim by Dyson personally. And he said, look, your average fair-minded, reasonable person would know that, you know, just because it's your company doesn't mean you have any say over the day-to-day operations. I mean, I must confess, I can see why that could have gone another way, really, because they could have argued and said, well, look, you know, I am the head of the company, I'm personally responsible. But anyway, they threw that out, but they allowed both the other companies to keep their claims going. Now at this stage, Channel 4 hadn't filed a defence or anything, because they said, we need to see that report. And they'd actually asked for it when they were interviewing one of the company spokespeople, because she was saying, oh no, this report clears us. And they said, well, if it clears you, why don't you let's have a look at it? And they wouldn't release it. However, once a claim is initiated, we get into what we call disclosure. And disclosure is, you must give to the other side any documents sort of pertaining to that case. Especially if it assists the other side by either bolstering their defence or undermining your claim. So that report was released, and apparently it did sort of suggest that actually you had been told about this. Channel 4, however, they filed their defence, saying, well, first of all, this is substantially true, but also it's, you know, it's a matter of legitimate public interest. You know, companies using sort of manufacturers abroad and cheap labour and all that sort of thing. So they argued on that. But, you know, they got the report as well. Now, because they filed a defence, generally speaking, when you do a claim, you file your claim form saying, this is what we say, if these are the facts that we allege, and if all these facts are true, then basically we win the claim. And you then file a defence saying, well, either we admit that particular fact, we deny that particular fact, or we don't admit it. If you don't admit it, you're saying we can't really say whether it's true or not, but we're not taking your word for it. You'll have to put some evidence in. If you actually deny a fact, you have to say explicitly what you're saying, you say the truth of the matter is. Now, generally speaking, once the defence is filed, then it all goes off for trial. However, you can put in what we call a reply. And a reply is where somebody alleges something in a defence. I mean, generally speaking, if somebody files a defence and you ignore it, you're basically saying, we reserve the right to challenge everything you say in the defence. But you can file a reply where you say, we specifically say, you're wrong about that, or you're wrong about this, and you'll put something saying, everything else is still an issue, just to sort of make it clear that you're not accepting what the defence says. But say, for instance, you allege something is qualified privilege or something like that. Qualified privilege is defeated by malice, but you don't have to put in the defence, we say this is qualified privilege and we say we weren't acting with malice. In the reply you have to say, well, we say this isn't qualified privilege because you were acting maliciously. And that's maliciously in the defamation sense, not in the everyday sense. That means either you know it's not true or you're reckless as to whether it's true or not. And there's a deadline coming up, and they said, this is your date to file your reply, and they didn't. Instead, they put in a notice of discontinuance. So what's a notice of discontinuance? That is literally a formal thing where you say, okay, we are discontinuing either the whole of the claim, or sometimes you say, well, we're discontinuing these specific bits of the claim, so we don't need a trial on this. But the rule when you file a notice of discontinuance is you are agreeing that you will pay the defendant's costs, subject to assessment and all that sort of thing. And apparently this was quite expensive. This has been rumbling on for 2 years, several £100,000 per side. But now, of course, Dyson, or Dysons, the two companies that were still left in it, they will have to pay all Channel 4's legal costs. But it's just like, it's one of those, that's a nice little thing to show you down there. I know you always like to see interesting nooks and crannies and stuff like that. There's a proper cave down there. On a future occasion, I'll go exploring down there. I won't do it today because I'd actually like to survive this one. Come back. So this, just like I say, this is an interesting example also of what we call the Streisand effect. You may remember Barbara Streisand, famous singer. She did a thing where somebody published like a picture of her house, and she was a bit worried about her security, so she tried to get an injunction saying, please stop showing where I live. And that all went to court. And because it all went to court, of course, it all made the news, and there were loads of pictures saying this is the house she's trying to keep secret. And instead of like maybe the 4 people who read the original article knowing where her house was, loads of people knew where it was. So I'm just showing you some nice pretty things to try and pad this out, because like I say, I just needed a subject to talk about, and I just went on to legal Twitter and everybody was going on about James Dyson. So this is an example really of the Streisand effect, because how many people knew that Dysons were made in a factory where people get like 10 cents an hour to work, and if they don't meet their requisite quotas, their supervisors take them off and beat their feet with bamboo sticks. And now everybody knows that. So well done, James. Is it James? I can't remember if he's James Dyson, because I think it's James Dyson's the cosmologist, isn't it? So that's basically it, really. So, a cautionary tale there. Be very, very careful, about initiating defamation proceedings, because all you end up doing is highlighting the attention. Although it also brings up interesting things about, who should be the claimant. Because like I say, they just kept referring to Dyson, whereas Dyson is lots of companies. Ironically, one of the key cases on identifying who the correct party is actually involved Channel 4, because there's Channel 4 News, separate organisation. And sometimes this will happen where you'll sue somebody, but you'll use the wrong name. And then it becomes an issue as to, have you sued the right defendant, inaccurately described, or have you sued the wrong defendant? I think I referred before, there was a really good thing where some Freedom on the Land people had brought a claim, and the judge was very snarky because he was just going to kick the case anyway, decided not to send them away to reissue. He just struck the claim out, but he put as list of defendants such and such, incorrectly identified as, just for a little bit of extra judicial snark. But there you go. I mean, that's pretty much everything about that case, really. I mean, like I say, defamation's a weird one now because we don't have juries, and the judges are arbiters of fact, as well as law. Most defamation cases do get struck out at a very early stage, because in the old days you'd go along and the judge would say, you know, oh, is this defamatory? What does this actually mean? Because it doesn't really matter. When you claim defamation, you have to identify, quotes, the words complained of, although defamation doesn't have to be words. There's a famous case where somebody objected because Madame Tussauds put his waxworks next to a load of serial killers. He'd been acquitted of a crime, but they still put his waxworks there. Because they put it next to all the people who had been convicted, they said that was defamatory. So, you know, you can actually make a statement just by where you place something. But in this particular case, it's like, you know, what is the meaning? And so the meaning is, it's really simple. It's just that Dyson, you know, use exploited labour. In olden days, though, whether it was a jury, you had to leave it up to the jury to find out what the meaning was. And the problem there is, you never quite knew what you were actually trying to defend. Because if your defence was, we say everything is true, well, what you're saying is true, because you're not quite sure what meaning the jury would put on it. Whereas now you go along and the judge will say, well, I don't care what you say is the meaning, Mr. Claimant. I don't even care what you say is the meaning, Mr. Defendant. I think your ordinary, hypothetical, reasonable person who is neither too naive nor too up for scandal, it's like, what would they think it all meant? And sometimes they'll come back and they'll say things like, this just isn't defamatory at all. I mean, that was always the test. There's that rather weird thing that it was up to the judge whether the words were capable of a defamatory meaning. That was a matter of law, but as to whether or not they actually were defamatory, that was always considered to be a matter of fact. But now, like I say, it would, you know, the judge being able to decide facts as well. It doesn't go before a jury. That's all a bit sort of tied up. So a judge might come back and say, I find the meaning is this, which is not defamatory, or I find the meaning is this, but that's clearly a matter of opinion. I mean, to argue something as opinion in defamation, the test is that it has to be your honest opinion. You have to identify the actual facts you are basing that opinion on. It has to be an opinion that a reasonable person could come to based on those facts. Now, unlike the single meaning rule, which is we don't care what everybody says, or if there are other interpretations as to the meaning, we're only going to find the one obvious one. And like I've done the videos before saying, everybody agrees that rule is really stupid. And the courts have said if we were starting defamation from scratch, no way would we actually introduce that rule. I'll just spin around, start heading back and try and get you a nice view of the island behind us. But when it comes to opinion, yeah, it doesn't matter if other people might have come to a different opinion. As long as a reasonable person could come to that opinion, then it counts. But the other part of the test that a lot of people forget is you must genuinely hold that opinion. So the mere fact that, say for instance, you know, a reasonable person could hold this particular opinion about somebody. Now, actually, you don't think that, but you just want to badmouth this person, then technically the defence would fail. But obviously, it's very hard because you know, knowing what somebody's state of mind is, unless they're daft enough to actually put in writing, I don't really believe this, I'm just saying it, then that bit is always sort of taken for granted. But it does sometimes come up. It cropped up in that Banks and Cadwallader case, as to, they actually put her to proof and said, we want you to give a statement saying you genuinely hold this opinion. And because, you know, their argument was no reasonable person could have come to this opinion anyway, and even if they could, we don't think you genuinely hold it, we think you just don't like our chap. So that's one of the hurdles that you have to get over. But that's why all this preliminary skirmishing is why very few defamation cases go to trial. I mean, very few civil cases generally go to trial. I mean, you know, 97% of issued claims settle before trial. And in defamation, it's even more. It's something like 99.9% of issued claims settle because the judge will say something early on and people will usually take a view. And that's clearly what's happened here. You know, you know, he's obviously employed very good lawyers. They've looked at this and gone, you're going to lose, mate, so you may as well throw the towel in now before A, you end up spending millions of pounds on a trial you're going to lose, and also there'll be tons of publicity about it, and Channel 4 will just you know, make even more of it. I mean, interestingly though, even though they've thrown the towel in on this, they're still zapping out going, we want injunctions to stop them saying this. Another thing about defamation is, there's a rule about, Hello. Oh, I love dogs. There's a rule in the case called Bonnard and Perriman against prior restraint. So, generally speaking, you can't get an injunction prior to the trial in defamation to stop them repeating the allegations. If it's a breach of confidence or a breach of privacy, then yes, you can. Because the argument there is, well, if we say you can speak about this before the trial, there's no point having the trial. Because if at the end of the day they say, yes, this was all confidential information, it's too late and you can't put the cat back in the bag. Sometimes people have got away with doing mixed defamation stroke privacy. There's a case, Ash and McKinnon, where it was basically a tell-all book by somebody's nanny. And the nanny, spoke and said, oh, it was terrible, they really, were terrible with the children and all this sort of thing. And they sued and said, well, that's not true. But in any event, the nanny is subject to a non-disclosure agreement that they're not supposed to say what happened at home regardless, because they have access to our family and our intimate secrets. So the deal was they weren't supposed to speak about it. And in that particular case, the court said, notwithstanding you're saying the allegations aren't true, we're still going to treat this as a privacy claim and we are actually going to allow the injunction. But you've got to be very careful doing that, you see, because normally, when you're arguing breach of privacy, only true information, by definition, can be private, because false information, well, it's just irrelevant, isn't it? It's not proof. It's not, you're saying it's not true, so how can not true things be private? But that was one exception. But generally speaking, if people do change tack and start saying, we're going to breach this claim in like privacy or harassment or something like that, you're effectively conceding that the allegations are true. So you've got to be very, very careful. When you do that. I think that's everything you need to know about sort of defamation and preliminary skirmishing. So as always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm at a place called Crantock, which is just across the water from Pentia, that headland, or Pentire, that headland where I do a lot of filming. But this is actually called West Pentire because it's the other side. And it's very, very pretty. And I'll just scan around so you can have a nice view and see what I'm looking at. I mean, like I say, 20 minutes ago when the sun was out, this was really, really lovely. I suppose I should think of a better slogan as well for the channel, because Dan's now got his, fresh, blunt and brutal. I'm not quite sure what my equivalent is. Reduced to clear, quite waffly, and I'm a bit of a no drama llama. So I don't come here for sort of the brutal takes or anything like that. This is more sort of me just meandering and looking at all the pretty flowers. I'll try and get myself my thumbnail picture. Just scan around a bit. So there you go. So that'll do as a thumbnail, won't it? See you next time. Also, my mum's down here, so I've just been showing my mum around. So hello to mum's friends who actually do watch these videos, unlike my mother, apparently. She goes, oh, no. She goes, I subscribe to you, I don't watch them. Cheers, mum.